Constituent Assembly as Legislative Assembly through an Executive Act. So let's just, then I'll come straight away to the issue, Miller's 1921.
1921.
Yes, PDF Miller's 562.
Yes, volume? Which volume is this, Mr. Sibal?
Same volume, Miller, same volume.
Volume 7.
Yes, same, Miller, the same speech, Miller. Comes a little later.
19.
Sorry, same speaker comes a little later, Miller. 11th August is the speech. Yeah.
1921. So PDF page 562.
562, PDF 562. Sentence starting, Miller's paragraph starting here, I would like to point out. My notes have that?
Just see some problem.
That's correct. That's correct. That's correct.
Yes.
All my lords have it. I'll read it. Here I would like to point out that the fact that Article 370 has been mentioned as a temporary provision, the Constitution does not mean that it is capable of being abrogated, modified, or replaced unilaterally. Kindly mark the words unilaterally, which is exactly what has happened. In actual effect, the temporary nature of this article arises merely from the fact that the power to finalize the constitutional relationship between the state and the Union of India has been specifically vested in the Jammu and Kashmir Constituent Assembly. That's how Muller's Parliament understood it in 370. That's how the state understood it. It follows that whatever modifications, amendments, or exceptions that may become necessary, either to Article 370 or any other article in the Constitution of India in their application to Jammu and Kashmir, are subject to decisions of this sovereign body. Since a good deal of confused thinking and uninformed criticism is indulging us in the interest of, I would like to point out here that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with the proviso that they may be extended to such other matters also as the President may by order specify with the concurrence of the Jammu and Kashmir Constituent Assembly. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of the Indian Union therefore clearly envisaged the convening of a Constituent Assembly for the state of Jammu and Kashmir, which would be finally competent to determine the ultimate position of the state in respect of the sphere of its accession, which would be incorporated as in the shape of permanent provisions of the Constitution. This briefly is the position which the Constitution of India has accorded to our state. I would like to make it clear that any suggestions of altering arbitrarily the basis of our relationship with India would not only constitute a breach of the spirit and letter of the Constitution, but it may invite serious consequences for a harmonious association of our state with India. The formula evolved with the agreement of the two governments remains as valid today as it was when the Constitution was framed, and reasons advanced to have this basis changed seem completely devoid of substance. In arriving at this arrangement, the main consideration before our government was to secure a position for the state which would be consistent with the requirements of maximum autonomy to the local organs of state power, which are the ultimate source of authority in the state while discharging obligations as a unit of the federation. Then Miller's kindly come PDF 648. This is Mir Qasim's statement on 10th November 1952.
Okay.
And this is exactly what I've been submitting before your lordships from day one. A unilateral executive decision cannot change the terms of a relationship which are constitutionally embedded in Article 370. Whereas PDF 648, page 2007, this speech was given by Mir Qasim on 10th of November 1952. In the statement of the Sheikh Mullah, that discussion on his statement continues. Whereas in the middle of that paragraph, starting, it is said that the accession of Kashmir with India should be, as far the statement is concerned, there can be no denying the fact that it should not be a dynamic in the sense that we give up our principles. On the contrary, accession should help us in achieving ideals and preserving our autonomy, except, of course, in the objects we handed over to India. Our assembly is competent to make laws and decide the issues, if any, since we are enjoying complete autonomy. We can even frame and amend our constitution. In this collection, we have application under connection. It should be with the application order of 1950 of the Indian Constitution. According to this order, all these powers do not vest in the state. Now, the next is important. We want to develop Kashmir according to the program of New Kashmir. Some people say that it is just possible that in future Kashmir may also become a part of India like any other state and get merged with it. In that case, our internal economy will be reduced to naught and residuary powers will be snatched from us. In this connection, I will submit that the thinking of such people is morbid. These are the vested interests which create such misunderstandings. The representatives of the government of India have not kept any time limit for these residuary powers. This is important. That's why, Malas, 370 talks about instrument of accession and the items in the concurrent list, but doesn't talk of list 2, which is the residuary powers of the state. Therefore, there should be no room for such doubts. We have acceded to India with a definite objective, and I am sure the objective will be achieved. Some interested persons are creating misgivings as regards the autonomy and say that Kashmir has been granted autonomy simply to benefit its Muslim population. But this is a baseless allegation. If the people from outside are not given the right of acquiring property in the state and getting recruited to state services, then it was not the Muslims of this place alone would get benefit, but all communities will also get benefit. Then let us kindly come to the social system which will be set up according to the program in New Kashmir will provide equal opportunities of development to all citizens of the state, be they Kashmiris, Ladakhis, or Dogras. Now, let's skip the rest.
69.
PDF page 694 now.
Formulate, now that we've seen the speeches, we'd like to formulate the principle which
The principle is, Madas, that an executive act of the Union of India cannot alter unilaterally provisions of the Constitution of India as applicable to the state of Jammu and Kashmir. That's the central.
Cannot alter unilaterally
Yes.
the provisions of the Constitution
Of India as applicable to the Jammu and Kashmir. Including getting rid of the special status given, acceded to by the Union, by the government of India, and by Parliament in enacting 370 of the Constitution. That's the submission.
Say it's an executive act.
I'll say 356 is executive, 367 definition is executive. These are all executive acts. Parliament came into the picture when the changes had already been done through executive acts. We're challenging that.
As you argued, the process was wrong.
Yes.
Whatever was done. But
Yes.
that is the parliament did it.
No,
Right or wrong?
Parliament accorded approval to the executive acts which unilaterally changed the constitution as it was applicable to the state of Jammu and Kashmir. That's the central question that your lordships will have to decide. Could Parliament have, could the Union of India have done it?
So is it your case that the parliament could have done it?
No, not at all. Well, that also I will answer. Well, let's kindly see. Ultimately, this was a political decision taken in the context of the situation then prevailing. Right? And the complete abrogation of Article 370 must also be a political decision. Well, your lordships will remember Brexit, what happened? In Brexit, what happened? There was no constitutional provision seeking a referendum. But when you want to sever a relationship which has been entered into, you must ultimately seek the opinion of the people. Because people are central to this decision, not the Union of India. It goes counter to the very grain of Article 370.
Mr. Sibal, in a constitutional democracy, seeking the opinion of the people has to be through established institutions,
Agree?
right? So long as a democracy exists, as it does, in terms of a constitutional democracy,
Yeah.
any recourse to the will of the people has to be expressed and sought in terms of established institutions.
I agree. So
There's no
either you
question.
do it,
So
either you do it. Malad,
you cannot envisage, therefore, a situation like a Brexit type referendum.
Yeah.
That's a political decision which was taken by the then government.
Yes.
But within a constitution like ours, there's no question of a referendum.
But Malad, this is a political decision that they have taken by unilaterally, Malad, through an executive order, changing definitions. This is not some constitutional decision. That's what your lordships, supposing your lordships were to say that they can change the definition, or your lordships were to say.
But therefore, the ultimate question is whether the constitution does or does not interest that authority.
That's correct. That's all that I'm asking, Malad. I'm not asking for anything more.
And which in turn depends on whether 370 is construed as you say, a permanent feature, irrespective of the terminology used, because that is in the context of the changes till the Constituent Assembly was there, or is it something which is capable of being?
Well, let me see. That's a much higher level, Malas, to which I'm not, in fact, arguing that today. Malas, whether it is permanent or it is temporary, let's forget about it. The central question is, can the Union of India, in this manner, terminate that relationship that is constitutionally recognized in Article 370?
You understand?
It may not be permanent. It may be permanent. It may not be. You may change it. You may. You may
I
have.
said in the context that that was the argument earlier. So we have come to the next argument, which is the manner in which it is done.
That's right.
Is flawed accordingly.
It's absolute. It's a fraud on the Constitution itself, according to me. It is politically motivated. It is a political act. These executive orders are political acts. They are not constitutional acts. That's my submission. And whether it is a permanent feature or a temporary feature is really at the moment not an issue. The reason why it's not an issue is maybe there is a constitutional way of doing this. I'm not addressing that. Nor have they resorted to that constitutional methodology. If they resort to it, it will be tested in a court.
And on the process, you said last time that, first, the Section 92 power was vested in the governor,
Yes.
independent of the Council of Ministers. Step
36,
2,
38.
right. Step 2, right. Step 2, the Legislative Assembly is dissolved by the governor under Section 53 without aid and advice.
Yes.
3, the proclamation is issued under Article 356.
Yeah.
You said that the object of the proclamation under 356 to eventually restore democracy.
That's right.
And not the decimation of democracy.
Right.
And then finally, we saw the amendment of Article 3 in the presidential notification.
That's right. That's
So
also an executive act.
all these 4 steps, according to you, were constitutionally flawed. There was no provision for these 4 steps because you've essentially taken away the powers of the State Assembly and exercise them under the garb of 356. That's the submission.
That's right. Absolutely, I'm deeply obliged to your lordship. But I just want to read one other.
Only one last thing which I wanted to ask you. You made your point on the process which was followed. They will have to answer it. On the proviso to clause 3 of 370, is there something ultimately that happened in the Constituent Assembly which sheds light on which way the Constituent Assembly was inclined to go?
Yes.
Because we are reading individual speeches. What happens thereafter at the end of this process
Well,
in 1957?
The Constitution was adopted in 1957
Yes.
by the legislature of Jammu and Kashmir. Between 1951 and 1957, they could have determined or terminated the essence of Article 370, abrogated it themselves and said, we don't want, there's no need for this Constitution. We want to be a state, the part of India, like any other state. That is why 370 sub-article 3 referred to the decision of the Constituent Assembly. That decision could have been taken. But my lord asked me the question, well, now that there is no Constituent Assembly, how will this happen? If it were deemed to be a temporary provision. That's what my lord put to me. Right?
So your argument would be really, I mean, if I can put it that way, that the proceedings in the Constituent Assembly of the state of Jammu and Kashmir would indicate a reaffirmation of the arrangement under Article 370 as a long-term arrangement.
That's right.
So that the three options that Sheikh Abdullah spoke about, namely either of joining Pakistan, acceding to India, or remaining independent, they gave up the first and the third option.
That's correct.
They decide that the ultimate decision was to stay within the dominion of India, but subject to the safeguards of 370.
That's right.
And therefore, according to you, 370 assumes a permanent character, irrespective of the nature of the provision which is envisaged in the Indian Constitution.
And that's what Sheikh Abdullah said in his speech, that look, this relationship...
That still begs one question as to whether it was enough that the Jammu and Kashmir Constituent Assembly proceeded on that basis. Could 370, which was envisaged to be a temporary provision, be converted into a permanent provision merely by the proceedings of the J&K Assembly? Or was there some further act required from the Indian Constitution, either in the form of a constitutional amendment, by virtue of which 370 would cease to have a temporary character but have a permanent character, in implementation of the wishes of the Jammu and Kashmir Constituent Assembly?
Whereas Government of India never expressed a contrary opinion throughout.
But didn't it have to take place through a process of amending the Indian Constitution itself?
No.
To convert the character of 370.
All right. Whereas now your lordships are again going back on the issue of temporary nature. That temporary nature is not part of the Article 370. It's not part of it. It's not a part of 370, Madam. In fact, Muzaffar Beg says we didn't even know about it. That's why I want to read Muzaffar.
Mr. Sibal, there are two ways that we could really lead into this discussion. One, that though placed in Part 21, Article 370 was never intended to be a temporary provision. That's one. That's one layer of reasoning, which is what you're advancing. Two, that though it was temporary, the reason why it was placed in a temporary provision of the Constitution was pending the decision of the Constituent Assembly of Jammu and Kashmir, and therefore it was given the character of a temporary provision, because the views of the Constituent Assembly of J&K were still to be elicited.
Right.
Third, that's the second argument. We accept that for the purpose of hypothesis. The difficulty, of course, which we have to face is this. Assuming that was why it was placed as a temporary provision, because the views of the J&K Constituent Assembly were still to be elicited. And we also take your point that the J&K Constituent Assembly decided to accede to India and reaffirm the accession to India subject to the safeguards of Article 370. Is that sufficient in itself to convert 370 into an unamendable or untouchable provision?
Let me assume, Malaj, that it is
not. Or was something more required by a parliamentary intervention in India post-independence to convert that which was essentially temporary into a permanent provision?
Let's assume, Malaj, that it is amendable for the sake of argument. Then, Malaj, how is to be amended? The Constitution must provide a solution, no, Malaj? I'll assume, Manas, for the moment that it is amendable. Then how does the Constitution of India must provide a solution for that?
Once we concede, Mr. Sibal, that concede in the sense for the purpose of the hypothesis. We're not putting anything in your mouth, not at all. So I don't misunderstand that. Once we accept the fact that 370 is subject to the amending power under 368, then equally 370 provides for a modality through which 370 itself would come to an end.
Well, let's see 370 then, Manas, and see what modality is. That modality can't be to convert a legislative assembly into a constituent assembly by definition through an executive act under 367(1). Then, Manas, we have to find the modality within the Constitution, not outside it, not vested in an executive power of the Union. That cannot be. So if your Lordship puts to me, and rightly, that something more had to be done under the Constitution of India, we'd like to know what is that something more.
But 370 bracket 3 itself specifies the conditions in which the abrogation can take place.
Which is the Constituent Assembly it must be on the recommendation of the Constituent Assembly. So it gives the solution. That is in line with the federated nature of this provision. This is complete federation, whereas we are quasi-federal qua other states. But these are purely federal qua Jammu and Kashmir, because the residuary power vests, Manas, in the state. So if you say, Manas, that C70 sub-article 3 provides that solution, but that is provided, certainly, but upon the recommendation of the Constituent Assembly.
And therefore, according to you, the power is completely lost once the J&K Constituent Assembly comes to an end.
Let me even not go that far. I'll assume that there is some power available. It may be 368. Let's say, it's hypothetical. We're not concerned with it.
No, Mr. Sibal, no. When you argue, then we'll have to take one. 360 is power to amend the Constitution. That's certainly there.
Yeah.
Now, when we look at 370 clause 3, now the issue would be whether 368 power is still available to amend the Constitution.
But your Lordship is not concerned with it in this matter.
No, it is. It's very, very crucial. Because once we accept the fact that Parliament as a sovereign lawmaking body has the power to amend everything, including 368.
Yeah.
370.
Including 370.
Yeah.
Then any amendment of 370 may be subject to criticism on the ground of morality, but not power.
No, but it's not an action.
Maybe it's a political argument, but not a power. It's not an argument of constitutional power.
This is not action under 368. Your Lordship is not going to hypothetically say this is an action under 368 when 360 has not been invoked.
But then likewise, the exercise of power under 370 bracket 3, can it not be then criticized? It's a question of criticizing it as a political criticism. But is it an argument of the absence of power?
Where is that in 370?
And the court is concerned with either the existence or the absence of power, right?
Not that I should ask your Lordships, where is that power in 370 that says that 368, you can do it under 368?
So 368 is the power to amend the Constitution.
But we are not, are we concerned with that here? I'm sorry, Manoj, you require 2/3. You represent.
There are independent avenues. You have the power to amend.
Manoj,
you have the power within 370 to abrogate.
But Manoj, in that independent avenue must conform to the provisions of the Constitution. Well, an independent avenue derogates the provisions of the Constitution is no avenue at all.
Mr. Sibal, for the timing, if we ignore the proviso to clause 3, in fact, the clause 3 itself, independent of the proviso, gives the power to the president itself to abrogate 370.
No,
if we forget about the
sorry.
proviso.
I'm sorry to say that, Manoj. I'm really
Just
sorry.
read
There is a
just read it
proviso.
once again. Just read
You
it once
can't
again.
exercise that power without the proviso.
No, the proviso is something different. We are examining the proviso independently. But independent of the proviso.
Clause 370 comes into play on the recommendation of the Constituent Assembly. Your Lordship is putting it the other way around. It comes on the recommendation of the Constituent Assembly that the President will exercise power, not the other way around. That's why I said you can't even initiate a bill. Your Lordship will remember that. You can't even initiate a bill. Forget about anything else.
Another problem is that then we would be redrafting the substantive part of clause 3 to postulate that the power under the substantive provision of clause 3 can be exercised so long as the Constituent Assembly of J&K is in existence. In which case, will the proviso not swallow up the main provision?
But that's what it says, that unless that recommendation is there, you can't exercise your power. President can't exercise power under 370, sub-article 3. It says so. Well, you'll have to interpret it on its plain terms, Malat, and the lordships have said it not once but several times over. And it's a provision which, in essence, is a provision of federalism. It's at the heart of federalism, is this, Malat. Yes, of course, it's a precondition. There's no doubt about it. I mean, whatever sophistry may happen, can't happen in this way, Malat. And whereas 373 power has been exercised by the Constituent Assembly, saying no recommendation. And I'll come to your lordships a judgment of Sampath Prakash Maras, which actually deals with this issue. So let's be clear, Maras. Sorry.
Where does the Constituent Assembly specifically says that it doesn't the sub-article 3 will not apply to the, it only says that it only exercises the 3 choices. First, as to whether it should accede to the Pakistan or to India or to remain independent. So out of 3, it decides that it will accede to India. But where does it specifically say that it recommends that sub-article not be available?
Let's go back, Malas, to 1950, 26th of January. Right? There was no Constituent Assembly. In fact, there was no decision. Originally, it was a National Assembly. There was no decision to convert it through adult suffrage into a Constituent Assembly. So Parliament, forget about the government, Parliament incorporated in 370 the provision for a Constituent Assembly. I asked myself this question, why? Why did Parliament do that? There was no Constituent Assembly in place. There was only a National Assembly. This must have happened in collaboration with Jammu and Kashmir. Must have happened, Malas. That's why the term Constituent Assembly was included in 370 sub-article 3. Now, when they said in the proviso that it's on the recommendation, there was no Constituent Assembly. So it had to be a temporary provision. It couldn't be a permanent provision. And the preamble of the Constituent Assembly says to further define the relationship between Jammu and Kashmir and India. So it was temporary because there was nothing in place. It was not temporary because this provision had to go. No. And therefore, that relationship was to be decided by the Jammu and Kashmir Constituent Assembly, which had to affirm all laws that had been passed. Even the laws could not be passed till such time it was ever confirmed during this period by the Constituent Assembly. So the Constituent Assembly actually was exercising a dual role at that point in time. And the government of India in 1950, in Parliament, recognized that it is the Constituent Assembly on the recommendation of which 370 will be abrogated. There would have been no constitution of Jammu and Kashmir. Let's put it that way. There would be no constitution of Jammu and Kashmir, Maharaj. If 370 had been abrogated, it would be yet another state of India.
Mr. Sibal, you've made your point now. I think basically, as we see it, your argument is in 3 layers. We looked at the background, the history. We look at 370 in the background, the constitutional history, the other history which we saw pre-independence. We interpret 370 therefore in the context of that history, and then we've gone to the modalities which were followed for abrogation, which you have said is unconstitutional. Now, after having explored this terrain,
let's
which is the next, how do we now progress?
Come back to the list of dates, Maharaj.
Right.
Well, with your 2 minutes I'll take. There is a speech by M.A. Beg, Afzal Beg, Just it'll take
Just
only
give us just the page and
Pages.
the gist of it, you can tell us.
at 694, PDF 694. It's only temporariness of the article. That's why that's the last person. You need not go through it. It refers to the temporary nature of the
It
article.
would be in the same vein as Mir Qasim's speech at 648.
And Mullahs, kindly note this, he was a representative of Jammu and Kashmir in India's Constituent Assembly. There were 3 members total, he was one of them. So he was part of the Constituent Assembly of India as well. I said that a good deal of criticism was leveled in both houses of Parliament of India and in the outside press in regard to the intention of 370, that it is a temporary article and the special position of Kashmir ipso facto is of temporary nature. This raised doubts and suspicions not only in the minds of the people of the state, but also in the minds of our colleagues sitting in this house about our relationship with India and Kashmir had peculiar position in 1947. It has now. That peculiar position is a permanent character of the state. It would be unfair to say that this position is a temporary nature. Statements have been made that in due course of time, 370 will cease to exist and Kashmir is bound to become a Part B state. Expressions like these have in fact given rise to amendments proposed by honorable members to the statements of the Leader of the House. Some of these amendments are critical and some are unfriendly. And then he goes on to say that we did not even know that there was a note, a marginal note in this regard. This has just come up suddenly. We didn't know that there was a margin. Nobody told us that there'd be a marginal note. So anyway, that's all that he said. I just wanted to invite my Lord's attention. So in my supplementary submissions, only I have set out these passages, nothing more than that. And so last try, so long as it is not completed, Article 370 will remain there. And when it reaches completion, we shall give to Paul what Paul's and what gives to Peter what Peter's. This is the center. That is, center will have the exceeded subject and the rest will remain here. 370 will have to be accordingly altered. It would not mean that Kashmir state will cease to have its special position. Amending 370 may be necessary at the time when we finalize our constitution. But even then, legally, constitution as it cannot in any way rob Kashmir of its special privileges and position given to it by common agreement. 370 is therefore temporary till we complete our constitution. That's the spirit with which it was incorporated in the Constitution of India. This is the point, Malak. Anyway, Malak, so that's what I've done with this. Now kindly come back to the list of dates.
The list of dates are in.
Yes, we were at serial 71 in written submissions, compilation volume 2, PDF 53.
Volume.
Which begins with serial number 72.
Yes, serial number 72. Let's read 71, 3rd of August.
Yes.
The governor of the state of Jammu and Kashmir, my lord.
PDF, Mr. Sibal, PDF?
PDF, my lord, 53, page 53 also.
Yes.
I'm sorry. Justice Call, my lord has it.
Yes, that's why I said serial number 72, 5th August.
71, my lord, I just want to read 71 also.
71.
The governor of the state of Jammu and Kashmir gave a press statement on the night of 3rd of August that he was not aware of any proposal to amend 370 or Article 35A, and that all security arrangements and reinforcements of the state were being made pursuant to intelligence inputs forecasting a major terror incident. On the 5th of August at 11 a.m., on August 5, the President issued the impugned order titled the Constitution Application to Jammu and Kashmir Order 2019. This is CO 272. Well, let's therefore mark, it's an executive act. The said order issued under Article 371 with the purported concurrence of the government of the state of Jammu and Kashmir inserted Article 367(4) of the Constitution of India. So that's what CO 20272 did. In particular, the newly inserted Article 367(4)(c) stated that references in the Constitution to the government of the state of Jammu and Kashmir would be construed as including references to the governor of Jammu and Kashmir. Further, 367(4)(d) amended subclause 3 of Article 370 by replacing the expression Constituent Assembly of the State with the Legislative Assembly of the State. Executive Act. Now, let's come and look at that. It's in volume 3, PDF page 101. That's right.
Volume 3 of what?
3
Documents.
of documents.
Document.
Yes,
Page 101.
101. Running page 494. Okay. Now kindly note, Malat, at this point in time, 356 was in operation.
Volume, Mr. Sibal, volume?
Volume 3, documents, volume 3, PDF
Documents
page
compilation. Documents compilation.
101. Note, Malat, at this time, 356 was in operation.
This is 5th August 2019 notification.
That's right. In exercise of the powers conferred by Clause 1 of 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, could never be done. Because other than 92, 36, and 38, Governor could only act on the aid and advice of the Council of Ministers. That's the Jammu Kashmir Constitution. The governor could not represent the state. So the very inception of this executive order is constitutionally flawed. In exercise of the powers conferred by Clause 1 of 370, the President, with the concurrence of the government of the state of Jammu and Kashmir, is placed to make the following order. This order may be called the Constitution Application to Jammu and Kashmir Order of 2019. It shall come into force at once and shall thereupon supersede the Constitution Application to Jammu and Kashmir Order 1954, because all amendments thereafter were to the 54 order, as amended from time to time. All the provisions of the Constitution as amended from time to time shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. So, to Article 367 shall be added the following clause. 4. For the purposes of this Constitution as it applies in relation to the state of Jammu and Kashmir, reference to this Constitution or to the provisions thereof shall be construed as reference to the Constitution or the provisions thereof as applicable or as applied in relation to the state. Reference to the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as Sadr-e Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And references to the government of the state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. How can that be? There is no Council of Ministers. So you create a constitutional myth. and assume in the absence of council of ministers that there is a council of ministers. And then you pass a presidential order that even in the absence of council of ministers, the governor is acting on the aid and advice of the council of ministers. What kind of exercise of executive power there is this? This is a mockery. Which is why I've been saying it's only a political act. It's not a constitutional act. You wanted to do something, you did it. D is even more serious. I don't think in any constitutional democracy in the world this has happened. In the famous Miller case in the UK, Manoj, Boris Johnson tried to bypass Parliament and requested the Queen to prorogue the House. The House was prorogued. Immediately, Manoj, matter came to the Supreme Court. All the justices of the court said, "No, Manoj, your Lordship knows this is the executive power of the government. They can prorogue the House." But all came to a unanimous decision. You cannot even prorogue the House like this. You cannot exercise executive power to bypass Parliament. You bypass discussion in Parliament. That's not the way constitutional democracies work. And this is much worse. You assume something that doesn't exist. You give powers to the governor, which he does not have. You assume to yourself under 350 all the powers of the state legislature. You are Parliament, so you therefore invoke the powers of the state legislature and Parliament, and you pass an executive order. What kind of exercise of law is that, or constitutional law? And then D, in the proviso to clause 3 of Article 370 of this Constitution, the expression constituent assembly of the state referred to in clause 2 shall read the legislative assembly of the state. What power does the president have to pass such an order? We're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power. (367) Huh?
Just assist us, from their perspective, why was the amendment to 367 necessary at all? Why was this crucial? I mean, we are seeing now the modalities which they have put into place. For their constitutional design of ultimately abrogating 370, why was this amendment to 367 necessary?
Because, brothers, they themselves gave the power of the Legislative Assembly, which they were exercising in 356 as the Constituent Assembly, and recommended. They were ad
Normally,
item with my interpretation.
Yes.
They were ad item with my interpretation.
Right.
That you needed the recommendation of the Constituent Assembly. So
They
how do you reach there?
They constituted the Legislative Assembly as the Constituent Assembly.
That's, and Malaz, what they do is they don't interpret it. They say in Proviso 3 of 370, the expression Constituent Assembly of the state referred to in clause 3 shall read as Legislative Assembly. So they have amended Article 370 of the Constitution. Shall
Actually,
read as.
367 amendment was not required because you are exercising
Was.
power under clause 1 to say article.
No, it was required because you needed the recommendation of the Constituent
No,
Assembly.
no, that's something separate. But in 367, introducing clause 4, in terms of the notification dated 5th August 2019,
You required it because, Malaz, they changed the definition of Constituent Assembly in 370 as Legislative Assembly. This is why they could exercise power under 356. Please appreciate.
But suppose for a moment that they had not gone through this exercise of amending 367, all right, or introducing 367(4), and suppose we are operating purely within the fold of 356.
Yes,
All right, your challenge to the 356 notification is a different issue.
yes.
Now just testing it as an exercise of power under
Very
356.
well.
Once a proclamation takes place under 356, two consequences follow. One, the president assumes to herself all the powers of the state, the executive powers of the state vest in the president. Two, except the legislature, the powers of the state legislature. Two, the powers of the state legislature are then subsumed in parliament. The government of India does not in its executive capacity exercise the powers of the state legislature. Parliament has to exercise the powers. So once the proclamation under 356 was issued, two consequences would follow. All the powers which were vested in the executive of Jammu and Kashmir were transferred to the president.
Correct.
All the powers of the state legislature were vested in parliament.
Right.
Now, if that was so, then if 370(3) is capable of the interpretation, just as a hypothesis, that it's a power to be exercised by the president to abrogate. They abrogate. Point number 2, any powers which were to be exercised by the state legislature would have to be exercised by parliament, so they had to go to parliament to get a resolution passed. Why was 367 necessary for the design, for the constitutional design to achieve this at all?
I tell you, 356 power cannot be exercised by parliament, by the governor, by the president and parliament in this fashion. Independent of 367, cannot be done.
Why?
Because you are only acting as the legislature. You don't have any powers independent of the legislature under 356. That's, Bomai has held that. You have no such powers. And the executive is only dealing with administration. It can't amend the constitution under 356. Therefore, they had to do this. There was no choice. I'll show Manas Bomai.
Yes, but assuming for a moment that we suppose we disregard the 367 amendment.
Even if you do, then you can't exercise it under 356 at all. That's even Manas, it will be a dead letter. It will be inchoate. Because you can't amend constitutional provisions, Manas, through 356. You can only exercise the power of the state. Parliament can do it.
Fair enough. Therefore, if that part of the notification, which amends 367, is kept aside for a moment, then what is the consequence?
The consequence is that 356 power cannot be exercised in the same fashion
No.
to achieve the same result.
See, the 356 power is the power of the state legislature and the state executive, which has now been vested in the president and in parliament, respectively.
Correct.
You may be right for a moment, subject to hearing them, that look, how can you exercise the power to amend the constitution by taking recourse to 356? Fair enough. We got that point and we'll hear them on that. But assume that we disregard this whole process of what took place under 367. Either disregard it or hold that it was constitutionally impermissible. Even so, does it affect?
That's a separate issue, Malad. I'll address your lordships on that.
Right.
At the moment, I'm on this executive order. I'll come to 356. I'll come to the other issues later, Malad. Because ultimately what you then do is Parliament is exercising power as a legislature and Parliament is exercising powers under 356 as well. Correct, Malad? And as a legislature of the state, let's assume, the state had to convert itself into a constituent assembly in terms of 373.
I think what they believed was they proceeded on a particular hypothesis that consultation with the constituent assembly is necessary.
That's right.
So therefore, they said that, all right, we are now going to replace the word constituent assembly by the word legislative assembly, which they sought to achieve by amending the constitution.
No, it's the recommendation of the constituent. It's not
Yes.
just converting it. You can't.
The first step was to amend the constitution.
Yeah, you recommend it to yourself because you have a political objective to recommend it, and Mullahs, you take the decision yourself.
Yes.
This is very problematic, Mullahs. And see the consequences of this. That means through an executive order, you can change any provision of the constitution because you have majority. But this majoritarian culture cannot destroy the edifice of what our forefathers gave us.
So your argument, therefore, is that you cannot exercise the power under 356 to amend the constitution.
Exactly.
That point you.
That's right. And they cannot possibly justify it unless there is some new jurisprudence that comes to light that they can do what they like as long as they have the majority. As it is, Mullahs, now one of your esteemed colleagues has said, Mullahs, that in fact basic structure, those theory is also doubtful. Maybe it is.
When we refer to a colleague, we have to refer to a sitting colleague. Once we cease to be judges, they are opinions, not binding diktats.
That's true. Of course, it's not binding, but I'm surprised.
On 11th of November 19.
Parliament doesn't discuss what goes on in the court.
No, I'm not
Court
discussing
should not,
anything.
I am not discuss what goes on in Parliament.
No, I'm not discussing.
Everyone, my lord, has a freedom
This
of
is a public
view, freedom of expression.
No, I know. Mullahs, I'll assume he has the freedom of expression, what he likes. I don't dispute that, Mullahs. I'm just saying, Mullahs. Of course, absolutely. We're starting a debate on that because of this majoritarian culture again. I said that 356 was already in place.
Mr. Sibal is responding to the parliamentary debate here because possibly he was not there in the Parliament yesterday.
That is true. That is absolutely true.
It was that place where he could have learned,
You are right.
expressed
You're right.
his views on basic
No,
structure.
not my view. I'm not, my view is clear because my view is the court's view. I can't go beyond that. But I am an officer of the court, Mullahs. In court, I have that constitutional view. Outside may have a different view. Mullahs, anyway, that's neither here nor there, Mullahs. It's just an aside, Mullahs. But there must be some element of humor and mirth in court as well, Mullahs. Not everything can't be this serious. We are dealing with, Mullahs, therefore, see the consequences of this. And Mullahs, then it is obviously clear that the government of India and Parliament recognized that the Legislative Assembly was the Legislative Assembly and could not be the Constituent Assembly, which is my interpretation. Therefore, it became necessary because they also knew that the legislative assembly can't be the constituent assembly. That's precisely what I've been arguing. And it says shall read. This is an interpretation clause. Please appreciate 367 is an interpretation clause. It's not a clause to substitute definitions. If you look at 367, the heading is interpretation. It's not substitution. You can't substitute definitions. You can only interpret. So it's outside of 367 itself, apart from many other things that I've pointed out.
What they've done is,
Yes. You're right. No, my lord,
So we saw this notification. Then what happened thereafter? We got your submission on this.
well, I just wanted to, mention this. Your lordship at one stage said the legislative assembly could be the constituent assembly.
No, no, no.
Legislative assembly
No.
is a successor
That
to
is
the constituents.
this is, we were saying what amendment they made. We didn't make a postulation that the legislative assembly could be the
Well,
one.
your lordship said that as a consequence, now that there is no constituent assembly, why can't the legislative assembly?
No.
Anyway, I was a mistake. I'm sorry.
That can never be a.
That's good. That's good. Anyway, Malad, let's move on, Malad. Let's move on. Now, Malad, I want to show your lordship the original 367.
Yes.
Original 367. That's in volume 1, PDF page 194 minutes. Page minutes, PDF 194, volume 1. That's the original 367 before the amendment, as applicable in Jammu and Kashmir.
Page, what page, Mr. Sibal?
194 minutes. Starts at 193, the 367 says interpretation, but the clause 4 is at 194.
Yes.
If I may read, for the purposes of this constitution, my Lord Justice Kaul has it?
Yes.
For the purposes of this constitution, as it applies in relation to the state of Jammu and Kashmir, reference to this constitution or to the provisions thereof shall be construed as reference to the constitution or the provisions thereof as applied in relation to the said state. No problem. Then references to the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as the Sadr-e Riyasat of Jammu and Kashmir, acting on the advice of the Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And then, Mullad's references B, reference to the government of the said state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. So mark that one. That was changed. No. Provided that in respect of any period to the 10th day of April 1965, such references shall be construed as including references to the Sadr-e Riyasat acting on the advice of the Council of Ministers. Because originally the Sadr-e Riyasat had to, till 1965, had to be appointed on the recommendation of the Assembly. A name would be sent and they would agree. In 65, a change was made, in terms of which, Mullards, the President could directly appoint the governor. That change happened in 1965 in the Constitution of Jammu and Kashmir. So like any other state. So slowly, in any case, Mullards, there was a slow but sure obliteration of the kind of autonomy that Jammu and Kashmir enjoyed. All laws were applicable, including TADA, POTA, UAPA, all laws are applicable there, except for land laws and personal laws. Most laws of India are applicable there at that point, in this point in time, in any case. So there was actually no need for any of this, except with the objective of sending a political message that we have done away with 370. That's why all this was done. Now, that's my submission.
After 2019 exercise, approximately 1,200 laws are now applicable. All beneficial legislations which are available to other citizens now are available to Jammu and Kashmir also. Prevention of Corruption Act was not applicable. Right to education.
There was. My learned friend is not right.
Several laws.
Anyway,
we have the list.
Let's not go into that. Let's not go into that. Prevention of corruption law was applicable.
You're right, Mr. Dwivedi, that's not a constitutional point, but.
Political optics, all laws were applicable.
Just to set the record right, the Jammu and Kashmir Prevention of Corruption Act, somewhat 2006, applicable. So it's because they were named differently. Anyway, let's leave that. Let's not get into this. References to the, then D, references to the permanent residents of the said state shall be construed as meaning persons who before the commencement of the constitution application to Jammu Kashmir order were recognized as state subjects under the laws in force or who were recognized by any law made by the legislature of the state as permanent resident. Reference to the governor shall include references to the governor of Jammu and Kashmir, provided that in respect of any period prior to 10th April 1965, such references shall be construed as references to the person recognized by the president as the Sadr Riyasat of Jammu Kashmir and as including references to any person recognized by the president as being competent to exercise the powers of the government.
Actually, they say in this notification of 5th of August 2019 that they're adding clause 4 to Article 367.
That's right.
But it appears that clause 4 already existed in Article 367. Right. So it was really an act of substitution, not an addition.
Not added.
That's a small thing, but it's a substitution really.
Correct. But clause D is in addition, where the Constituent Assembly must be read as.
C remains the same, right? C remains the same.
D is different.
Entirely. D is different, you're right.
And Miller's 2 also is also different. All provisions of the Constitution amended from time to time shall apply in relation to Jammu and Kashmir. And the exemptions and modifications subject to which they shall apply shall be as follows. All provisions of the Constitution
and
are now.
Old clause D goes. The references to the permanent residents of the state.
Yes.
That goes.
That goes.
Because that D is now substituted by the Legislative Assembly being treated as a constituent.
That's
assembly.
correct. That's correct. That's what happened. Let's go back to this.
There are 2 different strands operating here. One strand arises out of the exercise of the power under 356.
Correct.
Under 356, you have no power to amend the constitution.
Right.
If you exercise the power under 356 in relation to any other state in India, you can't amend the constitution. 370 is a provision exclusively in operation in relation to Jammu and Kashmir at the relevant time.
Correct.
So the power which they were exercising was the power under clause D of subsection 1 of clause 1 of Article 370.
Correct. Absolutely right. But unfortunately, Millers, they couldn't do that because clause 1 dealt with instrument of accession, subject related to instrument of accession, and then concurrent list issues.
No, clause D is wider than that.
Wider.
You're referring to clause A. We're referring to clause D.
Yes, I'm reading all clause A also.
D requires the concurrence of that government.
That's correct.
That is the J&K government.
That is government means government council of ministers, Millers. Government is not under the.
But tell us what happens when there's a 356 in operation in the state of J&K?
Well, let's put it this way, Millers. How does 356 in normal circumstances happen? Millers, the governor sends a report. The report is that the provisions of the constitution cannot be carried on in this particular state. The government of India under 356 Millers takes over.
Right.
Right. Now, at that time, the assembly is in suspended animation. That's the normal way that it is done. You keep the assembly in suspended animation, you exercise your powers. Ultimately, the intent is to restore democracy. Therefore, Millers, towards the end of it, when you know that elections should be held and you want restoration of democracy, you dissolve the assembly. And then you hold elections.
Oh, well, Mr. Sibal, the question put was slightly different. Now come to 370 clause D.
Right.
Such other provisions of the Constitution shall apply in relation to the state subject to exceptions and modifications that the President may by an order specify. Now, as far as this is concerned, therefore, the amendment was made to clause 4 to section 367, which is the interpretation clause. Now, the proviso says no provided further that no such order which relates to matters other than those specified in the last proviso, preceding proviso, shall be issued except with the concurrence of the government. The
Right.
concurrence of the government is the explanation
That's
part.
concurrent list subjects.
No, concurrence of the government
And the
is
Constitution,
the,
both
the
the
legislative.
Constitution of India as well as concurrently.
Let's assume Council of Aid and Advice of the Constitution of Aid and Advice of the Council of Ministers for the time being in office.
Yeah,
Now, when we turn to 356,
yeah.
now 356 applies.
Yes.
356 applies.
Of course, of course.
Now, if we turn to 356, then we have to go into what is the power if 356 provision has been invoked. Who will exercise the power of the Council of Ministers under the terms of Article 371?
Right.
So now the issue would be whether the governor could have exercised that power or not.
But at the moment, I have not reached 356, Malad. May I make my submissions when I reach it, Malad?
Okay.
This is, I will delve into another.
No, we are not on the validity of 356.
Exactly.
We are on the question of power.
Malad,
itself.
I'll be dealing with the power of 356, Malad, when we come to 356. What happens is that I will ultimately, Malad, my trend of thought will
They
be
get disturbed.
because I have.
But we just formulate it and leave it at that, that once upon the proclamation under 356, all the powers of the government of the state are vested in the president.
Administrative powers.
Yes.
Administrative.
Then can the president, in the exercise of the second proviso to clause D of Article
Amend the
371,
Constitution.
no, not amend the constitution,
Yeah.
exercise the power to grant a concurrence.
Malad, concurrence, what? Which subjects? Please appreciate. Either the applicability of the Constitution, right, with modifications and exceptions, or Malad's applicability of list in the concurrent list. That's all. That's all that there is. It can't be more than that.
And the president has the power to issue an adaptation order.
Yes.
Under the second proviso to clause D, the president can issue an adaptation order.
Correct.
When you have a regular government and a legislative assembly in place, you require the concurrence of the government,
Correct.
right?
Right.
Now, where the power of the government has been vested in the president under 356, it cannot be that the power of the president to issue an order of adaptation is taken away.
Correct.
Now, who will exercise that power, that power of
Let's assume the
concurrence?
president is, it can't be contrary to clause D of 373D. It can't be that, Malad.
No, but
That power can't be exercised by the
370, no, Mr. Sibal, 370D says that no such order which relates to a matter other than referred to in the last preceding clause shall be issued except with the concurrence of that government. Now, that government means the state government.
It
Now,
means
what-
Council of Ministers.
Council of Ministers. Now, what happens when a 356 notification is issued?
Malad, please.
In which case, will we say that that power cannot be exercised at all by the president?
I'm going to, I'll answer that then. Malad, kindly read Malad C and D, such of the other provisions of the Constitution. That is excluding Article 1 and 370.
Well, under D, the president has the power to issue adaptations to the constitution, which are all these orders that we are now seeing.
Other provisions of the Constitution, it says, D says that, Malad.
Okay.
Much of the other, excluding 1 and excluding 370. This is an amendment of 370 itself. How can the president exercise that power under D?
No, we are now looking at the exercise of the power to substitute 367.
Yes, but that effectively is the amendment to the Constitution,
The,
to C70.
Mr. Sibal, the president has the power to amend the constitution or create exceptions by taking recourse to the power under clause D, the second proviso. The president has an unquestioned power to do it.
Yes.
When there is a government in existence, it is conditioned by the requirement of concurrence. Now, what happens when the government has been superseded under 356? I'm just using superseded in a loose expression. If the government has ceased to exist by the exercise of the power under 356, The entirety of the power of the government is now vested in the
But
president.
even the government cannot change Article 1, 370, Jammu and Kashmir Legislative Assembly can't.
You're right, absolutely. Therefore,
The executive can't go beyond that.
you're right. Therefore, the government also has no power to amend 370 by itself.
No, can't change the scheme of 370. Forget about amendment.
But 370 itself postulates that it can be abrogated, and
370 says that it can postulate to efface Article 3, then I have no answer.
No,
Then I have no answer.
Mr. Sibal, the question was slightly different. The question is slightly different. Now, under clause D to section 371,
Yes.
the president by an order can make modifications to the provisions of the constitution as they apply to that state.
Well, please, I'm sorry to interrupt your lordship, but read the first part. Such of the other provisions of this
Correct,
constitution.
I'm coming
So
to
the
that.
modifications can only be.
We have understood that, just for the time being, just leave that argument apart, because one way to interpret clause C to section 3, article 371 is that it is only saying 1 and 370 will certainly apply to the state of Jammu and Kashmir. D refers to such other provisions of the constitution shall apply in relation to the state, subject to such exceptions and modifications as the president may by an order specify. For the time being, we're referring to 367, because the power under 367, there was 367(4), which was applicable even at the time of, in 2019. There was clause 4 of article 367, which was certainly applicable at the time, even in 2019.
Yes.
Now, if, in order to make modification to that clause,
Yes.
during, when 356 is invoked, what will be the procedure?
But that's an interpretation clause. That's not a clause to amend the constitution. I mean, I don't understand, Malad. I mean, obviously, I've gone something wrong in my understanding of the plain reading of the section, Malad. Obviously, I'm completely wrong. But with greatest respect, Malad, that's an interpretation clause.
Interpretation clause cannot be amended.
No, by interpretation clause, you can't amend 370. That's the power, with great respect, Malad. You can't substitute the legislative assembly, constitute legislative assembly. What has that got to do with interpretation? What you can't do directly, you can't do indirectly, Maharaj. And where does the president get that power when it says such of the other provisions of the constitution shall apply in relation to the state subject to such, that means other provisions of the constitution, you can have exceptions and modifications, not exception and modification 370. So I will not amend 370, but I will amend 367 to amend 370. With the greatest respect.
In your argument on that as well. 367(4), one second, 367(4) was brought in for the first time, not with the constitution, but in 1954. Right? So when 367(4) is brought in, if your argument is right, then the original insertion of 367(4) is also invalid.
No. That was interpretation. Maharaj, this is Damru. That's a case directly on point where your lordships have said governor was always known to be the governor. Sadr-e Riyasat was only the name. The argument was Sadr-e Riyasat prior to 1965 had to be elected.
Right. But
that straight away had to be elected. But in fact, now the governor was directly appointed by the president, right? He didn't have to be elected. So merely because there's a change of nomenclature, but if you change the substance of 370, considerations would be entirely different.
That's the submission.
That's held by your lordships. So let's not. There was no fundamental alteration there. Here there's a fundamental alteration. What you can't do directly, your lordships are now saying that let's look at 367. It's hard to find an alleyway to reach a logical conclusion. One can try very hard. But as I get lost when I go to my own.
Let's put it very simply.
Lost in alleyways.
Let's put it very simply. When Article 356 is in operation, how will you effectuate clause 4 to Article 370 clause 1, according to you?
I will, Malaj. Please let me reach that stage. I've tried to answer all your questions so far, Malaj. I'll answer that also.
So now we have seen the, that notification of
Manoj,
5th
there
of
are-
August and
there
the
are
original
two
Article
aspects to
367.
370, please remember. It says notwithstanding anything in this constitution at the beginning, and then it says notwithstanding anything in the foregoing provisions. 356 doesn't begin with that, with a non-obstante clause. It's important to know that even 373 says notwithstanding the above provisions. So it's notwithstanding of notwithstanding. So then how do you exercise that power in any other way? 366 has to be subject to 370. Doesn't say notwithstanding any provision of the Constitution, I can do what I like. Well, then you go back to Malak's, what we tried to get rid of in 1950.
Now say yes. Notwithstanding.
But that's why I said, no,
Yes.
This is now volume 2 of written submissions and PDF page 53. I was at item serial number 73.
Volume 2 written submissions.
73 minutes, 5th of August. PDF page 53. So the second paragraph at 70, members of the House raised objections.
Just 1 minute.
PDF, Mr. Sibal?
53, Malak, 53. Members of the House, my lords have that, raised objections that the bill had not been circulated. Then if and when the bill is circulated, time be allowed for reading and understanding the bills, and that only after the bill had been introduced was the supplementary list of business circulated in the House. The statutory resolution raised Jammu and Kashmir Reorganization Bill 2019 provided that the President of India had referred the Jammu and Kashmir Reorganization Bill 2019 to this House under the proviso to Article 3 of the Constitution of India. Just let's pause here for a minute. Now, if you look at Article 3, your lordships will find Constitution. as Constitution of India as applicable to the state of Jammu and Kashmir. This is document volume 1, PDF page 66. This is important, Malas, because remember, this is the 5th of August. The bill is passed on the 6th of August, but introduced on the 5th of August. So if you go to the Article 3 of the Constitution as applicable, you will find that the second proviso says, provided further, if our lords have that?
Yes.
Provided further that no bill
Mr.
providing.
Sibal, just 1 second.
I'm sorry.
Volume 1.
This is PDF 66, volume documents, volume 1.
Yes,
It says that provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. So there is no legislature, there is no legislative assembly. Governor has dissolved on the 21st of November, the assembly. You have to introduce the bill only with the consent, concurrence of the legislature. You introduce the bill contrary to the article. Because he says this is suspended, nothing exists. But by this time it's dissolved. How do you do that? Every executive act is constitutionally flawed, impermissible. It's a violation of the fundamentals of constitutional law.
yes.
First proviso says that provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, name, and states, the bill has been referred by the President to the legislature for expressing its views thereon. So the first proviso dealt with another states like Telangana when they were created. It had to go to the legislature for expression of views. Government of India may not. Parliament may not agree with those views. Of course, the power of Parliament given by the Constitution itself. So they introduced a bill without the legislative consent. I'll come to the reorganization bill later, but I just wanted to mention, because we're on this list of dates, that this itself could not have been done. Now, I kindly come back to my volume 2, written submissions. Let's skip this one. Yeah. It was not the legislature.
Governor's consent was taken.
Had to be, Malas. Not that we know, but yeah, it was. That's right. That's right. No, I'm sorry, Malas. Yeah. Yes. The proviso And then they gave consent themselves, took their own views. Well, they had to take the views of the legislature, they removed the proviso and took their own views. And on the basis of that. That's power. Yes, yes.
But give us the sequence. You told us last time, I think 19 December 2018, which was the documents compilation, volume 3, page 92, when the proclamation under 356 was issued,
That's right.
they
20th
suspended the
20th of-
provisions of the state constitution and proviso to Article 3 was also suspended.
That's right.
That's step one, right?
That's step one.
Then thereafter,
President's rule was extended from time to time.
yes,
On 3rd July, it was extended thereafter. And on 5th August, this happened,
5th of August, 19.
19. So originally, Mullah's 19th of June, just to get 2-3 facts right, 19th of June, Mullah's BJP withdrew support. 20th of June, governor exercised the powers to keep the assembly in animated suspension. 20th, the very next day, he didn't explore the possibility of a government being formed. Now, he had to necessarily, under the Jammu Kashmir constitution, hold elections within 6 months. When there were some attempts made in December to form a government, November, to form a government between the National Conference as well as PDP, immediately on 19th December, 21st November, he dissolved the assembly. The 6 months were not yet over.
So what is the date of that?
On 21st of November.
21st of November 2018.
18. He dissolved the assembly.
And can you just ask one of your juniors to give us a page reference?
I'll do that. Page reference.
Because last time some of the other we didn't take.
In a second one. My colleagues are adept at that. Volume 3, PDF page 89. Volume
3,
PDF page 89. November 21st, 2018, order. Here is what he says is, by virtue of powers vested upon me in terms of proclamation so-and-so 20th June 2018, issued under subsection 1 of 92, and in exercise of powers conferred upon me by clause B of subsection 2 of 53 of the Constitution, I hereby dissolve the Assembly.
Then comes 19 December 18, proclamation under 356.
That's right.
And the president suspends the proviso to Article 3.
Correct.
That's the next step.
Page 92. PDF page 92.
Yes, document compilation 3, we got that.
Then it's extended till 3rd of July. That's at page 95. PDF page 95.
Extension till?
For 6 months, Mother. From 3rd of July. And in between 5th of August, this happens, between the 6-month period.
Months was to end, huh?
Yes.
Fifth of August, he introduces it, Milad. First on 5th of August is the amendment order, Milad.
Yes, we saw the amendment order.
And then, Milad, he introduces this. Now, I'm going to not deal with the reorganization bill at the moment, Milad. We come, therefore, skip the date and come to CO Order 273, serial number 77. Now, we have seen CO Order 272, which I showed to your lordships, which is under challenge. That's the executive power as exercised by them, which substitutes, Milad, 367. That is CO 272. Now it's the CO 273.
You are back to we are in the
List of dates,
Yes.
volume 2, written submissions, written compilation, and serial 77. I've skipped the ones in between.
Okay.
Sure, once I read it. All my lords have it, Manoj?
Yes.
The president issued CO 273, which is also impugned, which is also an executive order in exercise of power under 370 sub-article 3 of the Constitution as amended by CO 272. Declared that Article 370 would cease to apply with effect from 6th of August 2019. So again, through an executive order, they passed an order saying this particular article would cease to apply. These are not legislative acts. Well, this is in volume 3, PDF page 103, the documents volume 3. What? Yeah, declaration. It's a declaration, not an order.
Declaration under Article 370.
Under Article 370 sub Article 3. How does which power does what power does the president have to make such a declaration? So which provision of the Constitution? In exercise, my lords have that? This is PDF page 103. Document volume 3. Does it show you not? Do you not see that?
It's reproduced in the BRF also.
Okay, okay. Maybe sometimes easier. Let's just have it. In exercise of the powers conferred by clause 3 of Article 370, read with clause 1 of Article 370 of the Constitution of India, the President, on the recommendation of Parliament. Now, let us see this. So, Parliament, that is, acting under 356, becomes the Legislative Assembly, recommends to itself, exercising the powers under 370, as a constituent assembly, and then says that 370 ceases to exist. So you mullahs therefore assume all the powers of the state legislature, of parliament, of the constituent assembly, and give consent to yourself. Recommend to yourself and accept the recommendation yourself. So amazing exercise of constitutional legerdemain. Therefore, he says, Miller, that all clauses of the said Article 370 shall cease to be operative except the following, which shall read as under, namely, all provisions of this Constitution as amended from time to time without any modifications or exceptions shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in Article 152 or 308 or any other article of this Constitution or any other provision of the Constitution of Jammu and Kashmir or any law, document, judgment, ordinance, order, bylaw, rule, regulation, notification, custom or usage having the force of law in the territory of India or any other instrument, treaty or agreement as envisaged under Article 363 or otherwise. Go back, Mullahs, to the list of dates.
They accepted the J.
So now we've time.
12:56.
6. So I know, I know, I know.
Yes.
There's a very serious thing that's happened in Gurgaon, mothers, where mothers, there is a call along with policemen to say that if you employ these people in these shops, you will all be gaddars. Mothers, this is creating, so if we file an urgency petition, your also may look at it at lunchtime. That's all.